Hello everyone and welcome back to the channel. Hope you're all keeping well. And thank you for all of those who've been following the series of videos so far and subscribing. Just a reminder, it does take a lot of time and effort to make these videos, so appreciate if you do like some of the content, then if you can subscribe, it will help me make further videos in the future. Just a reminder what we've done so far. So currently we're working our way through the criminal litigation series of the bar course, and we're working our way through the journey of a criminal case all the way from the arrest and charge up to sentencing and appeals. And this is primarily for bar course students. It's not a detailed look at the syllabus, just an overview snapshot, just a refresher. And also for the general public, it can help just understand the criminal process if you know anyone who's going through any troubles. So today we examine chapter 5, and this is the criminal evidence and the burden of proof. So it's a fairly detailed video. We'll try and cover it in enough detail so that you get a good understanding of it. However, I don't want to make the video too long, and we'll cover the other elements in the future videos. So evidence. Evidence is the foundation of every prosecution and defense case, and it's the bridge between the allegation and the truth. But not all information can cross that bridge. The law filters out what's unreliable, what's irrelevant, and what's unfair. So throughout this chapter, we'll explore how the court decides what evidence can be used, who carries the burden, and how fairness safeguards justice. Just a reminder, this presentation is for educational purposes only. It's not forming any legal advice. If you do have your own personal issue or legal issue, then contact a solicitor or legal representative for advice. So in criminal proceedings, the prosecution bears the burden of proving the guilt. So you may have heard in certain crime TV shows or films, the burden of proof. So beyond reasonable doubt comes to mind. But the prosecution bears the legal burden. So it's up for the prosecution to prove that someone's guilty rather than the defendant proving that they're innocent. And this is the golden thread identified way back in cases such as Wilmington and the Department of Public Prosecution's 1935. And the duty to prove guilt never shifts. So the defendant is presumed to be innocent until proven guilty. Certain statutes impose evidential or reverse burden for specific defences. So although the overall burden is on the prosecution to prove that you're guilty, if you're trying to make a claim or a defence, you need to bring that case forward, and the burden then shifts. It's called a reverse burden. So specific defences, for example, reasonable excuse under the Misuse of Drugs Act 1971, or lawful authority under the Firearms Act 1968. So just think of it where the defendant is trying to prove a point within a case. So a case within a case, the burden can sometimes shift. However, unless Parliament clearly provides otherwise, the legal burden stays with the prosecution. Where a reverse burden does apply, the defendant usually meets it on the balance of probabilities, and we'll look at that on the next slide. So it will be a much lower threshold for the defendant. So what do we mean by the balance of probabilities? So the standard of proof. Standard of proof sets how sure the tribunal must be. So in criminal cases, guilt must be proved beyond reasonable doubt. And then this is expressed today as along the lines of so that you are sure something happened. So for the jury to find someone guilty, they must be sure, based on the evidence, that the defendant was guilty. However, in civil proceedings, so where there's like a civil case, a civil harm or a tort or a contract dispute, or if you're taking someone to court, Over a civil matter, it's a balance of probabilities. So more likely than not. So some people like to deal with this in percentages. We try not to look at percentages, but if you're from a mathematical background, more likely than not would be 51%. Anything over 50%, it's more likely than not to have occurred. So the threshold's a lot lower. It's a lot easier to prove in that scenario. And this difference reflects the consequences. So liberty is at stake in criminal cases, whereas it's liability, often the case in civil cases. So there's a lot more at stake in criminal cases. In hybrid proceedings, such as contempt of court, the criminal standard does still apply. But the judges remind juries that beyond reasonable doubt does not mean all doubt, only that they are sure of guilt based on the evidence. It's always got to be based on the evidence. Only relevant and fairly obtained evidence is admissible. So the judge acts as a gatekeeper, ensuring fairness under PACE 1984. We looked at PACE in a few episodes ago, and the Criminal Justice Act 2003, and also common law. So the central test asks, does this evidence help prove a fact in issue without unfairly prejudicing the accused? And evidence obtained through serious breaches, such as unlawful searches or coerced confessions, may be excluded, even if it is probative. So we did touch upon PACE and some of the codes and conducts of police. And if procedure isn't followed, then even if the evidence is strong, sometimes the evidence can't be admitted. And we also talked about, I think it was on episode 2, PACE, police powers. If it was an unlawful arrest, so maybe the caution wasn't given, then sometimes that could be detrimental to the case also. So these are very important issues to bear in mind. Judges constantly balance probative value against prejudicial effect, ensuring that trials decide truth without bias. So overriding objective fairness must be there throughout. So what are the types of evidence then? So evidence can be direct, circumstantial, real, or documentary. And in the bar course, you will go into a bit more detail and have practice scenarios where we can look at the differences. But just to summarize, just a brief summary. So direct evidence provides or proves a fact without inference. So an eyewitness identifying the accused, that would be direct. Circumstantial evidence relies on inference, so fingerprints, motive or opportunity. And then you've got real evidence, which includes tangible exhibits such as weapons, clothing, or CCTV. And then you've got documentary or digital evidence, which includes written or recorded materials. So each item must be authenticated through a reliable chain of custody to ensure integrity from seizure to the courtroom. What about hearsay evidence? So you may have come across hearsay in common English language. It's infiltrated within like an everyday term in English language. But we will look at hearsay. I think I'll do a standalone video on hearsay because it can be quite complex and detailed. We're just going to have a quick overview of it on this episode. So hearsay is an out-of-court statement offered to prove the truth of what it asserts, and this is governed by the Criminal Justice Act 2003, Section 114. And it's generally inadmissible because the original speaker cannot be cross-examined. So you've got to remember, anyone can say something on a statement or at a time, but sometimes the truth or closer to the truth comes out when the various lawyers start cross-examining the witness and it starts to unravel. So it's not as reliable as being there live in court, being cross-examined. So an example would be a witness saying, "Sarah told me," the defendant confessed. So Sarah's words are hearsay in this scenario. Yet the Criminal Justice Act 2003 recognises that some hearsay is necessary. And under Section 114, subsection 1D, a statement may be admitted if it's in the interests of justice. And then you've got section 114, subsection 2, which lists 9 factors that the court must weigh, which includes reliability, motive, corroboration amongst them. But the rule protects fairness, but modern law balances principle with practicality. Don't get worried if this seems a bit detailed at this stage. As I said, I think I'll make another video specifically on hearsay at the end of the series, so wait for that video. The Act does provide structured exceptions. So section 116 is whereby a witness is unavailable. So this could be for various reasons: death, fear, illness, absence. These are all exceptions, so that this is where hearsay could be accepted. Section 117, so it's a business or public document made in the ordinary course of business. You've got section 118, common law exceptions like res gestae, public records, reputation evidence. So courts may also admit hearsay in the interest of justice, where reliability is high and cross-examination is impossible. So judges remain vigilant under section 121 to exclude unreliable hearsay. But the principle from the case, the Crown against Horncastle, 2009, that was in the UK Supreme Court. And that confirms that convictions can rest partly on hearsay, but must include sufficient safeguards to ensure fairness. And we've got some unfairness is also covered. Unfair evidence is covered under section 78 of PACE. So the court may refuse to allow the prosecution evidence if the admission would have an adverse effect on proceedings. So the focus really here is on fairness. Also police impropriety and unreliability. So we talked about the early stages of the process in the second video of the series. And also factors such as the seriousness of the breach, centrality, whether deliberate or reckless, or if there's alternative means available. These are all important factors that the court considers. Another important type of evidence is character evidence. So you can imagine, just say, if someone's on a rape trial, a defendant is being accused of rape, and let's just say they've got 7 or 8 previous convictions of rape. Surely this could be relevant, you would say. And you could alternatively have someone who's he's not guilty or is innocent. He's on trial for rape, and he's got another conviction which is completely unrelated. So when he was younger, did some shoplifting or just low-level theft. So how does the court look at this? And this is all about character evidence. Again, this is another large area, so I think I'll make a standalone episode on character evidence. But for now, we're going to look just briefly at it, because it is one form of the evidence that can make its way into the trial. So character evidence reveals aspects of the defendant's disposition. So under the Criminal Justice Act 2003, subsections 98 through to 113, the prosecution can adduce bad character only through one of the 7 gateways in section 1011. And for instance, all parties agreeing, or where it's relevant to an important matter and issue, like propensity. So we talked about propensity. If someone's got propensity to do a specific crime, surely that you would think that this could be relevant to this particular case, previous behaviour. Even then, section 101, subsection 3 allows exclusion if admission would unfairly affect the proceedings. So we talked about the shoplifting case. And we've got to always balance fairness for the defendant versus giving a full picture for the jury. Remember, the jury needs to base their decision on the evidence put through to them. And ordinarily, the evidence would be what comes out at trial, whether that's through the witnesses or the cross-examination. But if there are relevant previous convictions, then this could also be an important factor for the jury. So it's that balance about being fair to the defendant versus making sure that the right outcome and the right portrayal of the character is given to the jury. So the defense may introduce good character also, and this is supporting credibility or lack of propensity. And the case of the Crown against Hansen 2005 clarifies that past convictions must demonstrate real relevance and not mere prejudice. So this is what we're talking about, the relevancy of the convictions. So just looking at these are just some of the 7 gateways. You will have to learn to memorize these, but these gateways are, so the gateways you're going to learn are for hearsay. You've got the set that you need to memorize, and also for bad character, the 7 you need to remember. And again, these are some of the reasons just listed here. We will go into more detail in a future video, but all parties agree, then of course they're going to let it be admitted. If it explains something important within the case and it's necessary, then that would also be supportive of it being included. And if it's relevant to an important matter and issue, e.g. a propensity to offend, this is where the chap who's on trial for rape and he's done 7 previous rapes and the other one was fairly recent as well, this could be relevant. Substantial probative value regarding an important matter between co-defendants, and also putting right a false impression given by the defendant. This is one of the gateways, one element of the gateway. And also attacking another's character opens the door to one's own character. So if the defendant starts attacking another character and their own bad character was previously not, it didn't pass the threshold to be brought into the case, sometimes by the defendant attacking someone else's character, it would lead to an opening of this gateway, whereby it could be admitted if the court deems fit. Just go back to the character. Sometimes also closely linked to character, similar fact evidence highlights patterns so distinctive they defy coincidence. So there's a case called the Crown against Boardman, 1975. If you wanted to pause the video and just look into that set the standards there. Similarity must be striking enough to make coincidence improbable. And today, such evidence is usually analysed through the bad character gateways under the Criminal Justice Act 2003. But judges must carefully instruct juries to use it only to identify pattern or intent and not moral judgment. I haven't actually got some slides here, but I think it's important to discuss confession evidence as well. So a confession is any statement adverse to the defendant's interest under PACE, and this is section 82(1), must be voluntary. And section 76 requires exclusion if obtained by oppression or circumstances making it unreliable. So we talked about the PACE codes, and if you watch a YouTube Shorts video, I'll put the link in the comments below. There's an example in that where the police officer's pressurizing the defendant to make an admission or even a confession, you could say. And the police's behaviour need to be looked at under the PACE codes to see if the confession was legitimate or if it was under duress. So what about expert evidence then? You've probably heard about experts being called into trials as well. So expert testimony assists where matters exceed ordinary understanding. So think of forensic science or medicine or technology. Sometimes where the lay person alone cannot identify, let's just say there's a car accident and there's tyre marks on the road, there's been a death by dangerous driving case. And you need to bring in some sort of forensic expert to examine the tyre tracks on the road to ascertain what speed the driver was driving. I mean, a lay person or observer could probably tell just by the length of the tire marks that it would have been fairly fast. But if you've got someone's liberty at stake here, you need to bring in some sort of expert. So experts are needed in certain cases. And under the Criminal Procedure Rules, Part 19, experts must be qualified, independent, and owe their primary duty to the court. So they don't necessarily need any qualification as such, any formal qualification. However, in the form of a degree or whatever, but they need to demonstrate that they're an expert in this particular field and that their only duty is to the court. So they're only dealing with the matter that's been put to them, such as the tire tracks on the road. They must disclose their methodology limits and any uncertainty. And courts discourage the hired gun approach, whereby the expert aids the fact finder but does not decide the guilt. So cross-examination tests impartiality and the soundness of the opinion. So the experts are on the stand. Most times the expert furnishes a report which goes to all parties. They draft a report based on their opinions, but they get cross-examined like any other witness on the stand. And this is where sometimes the robustness or even impartiality of the witness comes into play. It's important to remember that any witness on the stand can only give an opinion on the facts that they observe. So for instance, if a bystander sees someone push someone over in a nightclub and there's a charge of assault, they can only make an opinion on, say, how hard the push was or how quickly he got away based on everyday interpretation of those types of facts. So witnesses may not give opinions, only state facts where they're observed. They can't give an opinion on something. The exception is where the witness is qualified as an expert, as we saw on the last slide, and their opinion may be admissible. Expert evidence permitted on matters outside of ordinary knowledge. So we talked about medical, forensic, scientific, and the court must be satisfied on the expert's qualifications. So we talked about the nightclub scenario. Lay opinion, e.g. speed, handwriting, may sometimes be allowed, but narrowly, and it's up to the court to decide. So we're talking about evidence here, and then it will involve witnesses also. So witnesses are either or both competent and compellable. So are they competent? Have they got the right frame of mind? Have they got any mental health illness where they don't understand what the consequences are if they lie on the stand, for instance? And are they compellable? Do they have to, if they're summoned to court, or do they have to come to court? Can they say, oh, I don't want to give evidence? So this is competence and compellability of witnesses. Competence, you can see how this could relate also to youth witnesses as well. So can a child be put on the stand, you would think? Do they understand the gravity of a trial and making sure that they give factual evidence? This is where the youth acts come into it. So Section 55 of the YGCEA 1999, all persons are competent unless they cannot understand the questions and give answers which can be understood. And you've probably seen in various courtroom dramas oaths and affirmations. So they need to have the ability to take an oath and also understand the consequences of going against that oath. So this could vary depending on the person's mental health or cognition or even their age. Compellability, so the general compellability. There is a general compellability. They have to attend court if you're asked, except certain exceptions. You've probably heard of spouse privilege, but they can be compellable for prosecution of specified offences. So violence, sexual assault against a spouse or a child, and this is all covered by PACE, Section 80. Apologise for the typo there. Children's, the competence, again, it's the same test and special measures under the YJCA 1999. So what about identification evidence then? So we touched upon an example about someone witnessing an assault in a nightclub. And how sure are they that the defendant was the actual perpetrator? So the central rule of identification evidence and the strength of that type of evidence comes from a case of the Crown against Turnbull. So if you did want to pause the video or read up on that case, you can read up on it. But there's special caution in certain cases where the ID of the assailant is central and integral to whether they're going to be found guilty or not. So judges must warn the jury of dangers of mistaken identification. They must consider the circumstances, so things like lighting, distance, duration, stress of those involved, familiarity. These are all important factors in assessing the quality of the identification by the witness. And supporting evidence required before the conviction is based solely on ID, and this is governed by PACE Code D. I just wanted to say, hopefully you did find that video useful. It is quite difficult to sum everything up within a short video. So as I said, I will look into more detailed standalone videos for hearsay and also bad character. We'll also look at privilege. I think is a good idea to look at privilege in a separate video. So certain communications remain privileged. You may have heard about privilege, and we will dive deeper into that. So just as a spoiler alert, legal professional privilege shields confidential lawyer-client advice, and then there's something called public interest immunity, which may restrict disclosure where national security, terrorism, or informant safety is in place. And courts need to balance these immunities against the right to a fair trial under Article 6 of the ECHR, ensuring disclosure where necessary for justice. So the constant aim is always to protect both fairness and the public good. But that'll be for a future video. Hopefully you found this video helpful. As I said, it's a lot of content to cram into one video, so we will make some standalone videos. But just a reminder of what we've discussed here. So the burden of proof lies with the prosecution as a general rule, and the standard in criminal cases is beyond reasonable doubt. So you must be sure that the defendant's guilty to convict them. Evidence must be relevant, admissible, and fairly obtained. And we looked briefly at hearsay, character, confessions, expert evidence, and also we'll look at privilege in a future episode, I think. So these principles all go hand in hand in ensuring that justice in English criminal courts is not only done, but seen to be done. So thanks for watching this episode. I hope you enjoyed that. If you did have any questions on today's episode, I do try to answer as many questions as I can. So just drop it in the comments below. But really grateful if you can subscribe. It will open up more possibilities for more videos in the future. The next episode we're going to look at is going to be disclosure and case management. So what documents need to be disclosed, and what evidence makes it and what doesn't make it, what's classed as unused material. So that's going to be on chapter 6 in the next episode. But as I said, thank you for watching, and it's bye-bye for now. See you in the next episode. Take care.